Good afternoon, everyone. Desi Kaanoon today is in conversation with Advocate Rahul Tiwari, sir, and we'll be talking to him about his experience in legal education in the litigation industry and a lot more. So stay tuned, and this interview will also be uploaded on our social media handles and YouTube handles as well. So I would like to welcome Sir Rahul Tiwari, sir, and thank him for his time today. I think we should begin with the interview now, sir.
Yes, sure. So,
Okay.
this is Advocate Rahul Tiwari, and I'm a practicing lawyer in Gurugram District Court and Delhi High Court. So, that will be my short introduction. Rest, you can just type Advocate Rahul Tiwari on Google and you'll get my LinkedIn ID, and rest all the details are present over there. So, yeah, you can ask me questions.
Amazing. Okay, so firstly, sir, I would like to talk to you about your experience as a moot court judge in moot court competitions. What is the most important factor that you consider in a team while judging a moot court competition?
The thing is, I have just closed 17 competitions, okay, and as out of them, 8 were moot court competitions, okay. And what actually happened that I realized that the people people what they do is that they first focus on the law, then the problem, okay. But the thing is, first they have to focus on what is the fact, okay, and the facts of the case, the knowledge, the research part, and then the drafting part. But people do it, opposite way. And the biggest problem is that, suppose there is a moot court problem which has been given to them. What actually they do is that while drafting their moot court memorial, they focus a lot on the question of law, on the issue number 2 and issue number 3. But the research part is simply horrible in the issue number 1, which is the jurisdiction part. And I keep saying them that, when you are preparing for your moot court competition, please focus more on your jurisdiction part. Okay, the focus should be on the jurisdiction part, that if you have approached the Supreme Court, then if you have approached the Supreme Court via writ petition, via SLP, or via PIL, then do you have the jurisdiction to file the case or not? And if are there any alternative remedies available to you or not? Or in fact, if and under what jurisdiction or under what judgment which allows that if the alternate remedies are not being exhausted, still you can approach the court, and still you can approach the court and plead for your case. So all these things, the first issue is the important aspect, but that's the problem, that people don't focus on the issue number 1. So just take it for an example. Take an example like this, that if the judge is not convinced, then, or if a judge knows that you shouldn't have been here, you shouldn't have been in this court, and you don't have a jurisdiction to file the case, then why would he listen to your other issues? So that's the biggest problem which the student commits while they're moot court their moot court memorial drafting, and in the argument also. Okay. Thank you.
Yeah, I think that is a very important observation, because I have seen some of my juniors also, they don't tend to spend time on issue number 1, and they are more concerned about establishing their case through other issues.
Exactly.
So I think this is a major point of concern.
Yes, it is in fact, because that's where these people actually end up getting drilled.
You also have right
Network issue, I guess. Yeah, go on.
Yeah. So you also have interest in legal research. Also, you have worked as a research assistant with the Advocate on Record, Mr. Shamshad, on Babri Masjid issue. So what do you think is the thumb rule to legal research for both beginners and experienced professionals?
See, the research is people don't realize that research is the most important aspect for any advocate. And I keep this saying in my various webinar also. And if we count this as a webinar, it will turn out to be my 30th webinar. Okay, so people needs to understand that the research, the lawyer wins their legal research, their cases with their legal research done in the chamber, not in the arguments which they do in the court. Because what is argument? What is written in your plaint? That's what you argue. And what is written in your plaint or your petition, which you research. So important aspect is your research, drafting, then argument. But what people think that moot court is all about, it's your speaking skills that you want to be in Harvey Specter, and this thing that एक तो suits ने बर्बाद कर रखा है हमारी generation को. Trust me. And to all those people who watch Suits and have that fantasy that they are going to be the Harvey Specter when they enter the profession, guys, please leave the profession then, or else change your profession. There is nothing called Suits, especially in the Indian legal fraternity. You won't find an iota. You know this word iota, a part, a minuscule, a molecule of Suits in the legal fraternity, is even in the top law firms. So guys, please, just stop. I mean, just if you want to watch Suits, watch it for entertainment purpose, not for any reference purpose. Please, you will set a very wrong expectations for yourself. Okay, so the point of the legal research is, the thumb rule is, first of the legal research is where you try to explore. Then suppose you are working on under an advocate, then the thumb rule of the legal research is, first you see what is the fact of the cases, what are the laws available, and where the violation of law has taken place, and how you can interpret the law. Okay, there are three areas of interpretation, like the literal rule, the golden rule of interpretation, which narrows or which widens the scope of law, or in fact the rule of the interpretation of mischief, where you try to identify the area which is not mentioned in the law, and then how you apply the law to the violation of your client and what you pray. So all these things involves your legal research. Now, for academicians, for students, or those advocates who are actually working in the think tank, what actually happened? There, how do you do the legal research? You analyze what is the present lacuna in the law, then either you do the doctrinal research, or either you do the doctrinal research or you do the empirical research. Then you identify on which areas we have to work upon, what is the present lacuna in the law, and what is the reform which you actually need. So that's where you suggest changes in the particular law. Okay, and for this purpose you do the comparative analysis also, like for example surrogacy. Now commercial surrogacy is banned in India. The surrogacy, after even after the present suggestion by the upper house, still live-in relationship couples are not allowed for surrogacies. And regarding the homosexuality part, then that's where we have to compare that which country allows surrogacies for the widows, for homosexual, for live-in couples, and how it can be applied in India. Then if the second part of the research says that if it is applied in India, what all problems we will face while the execution of such laws in India, and how do we deal with it. So all these things are related to research, and that's where people have to realize that legal research is the most important aspect for any advocate, whether it's a lawyer or a law student.
So I would also want you to share your experience as a faculty, and also tell us about So Legal.
So Legal is a coaching where I had applied to teach, because in the pandemic I thought that when I was not getting client on the regular basis, that I can also teach, because I'm also a judicial service aspirant. So that's where I thought, but luckily it turned out that I had a lot of I went to my third year of my practice, and I would say that touch wood, I had a lot of support from my senior. So there was no dearth of work, but still, the teaching has been my passion. So I thought that yes, that's where I'll be in touch with the academics also. So I decided to join Soligal. I gave the interview and my CV was selected. So that's where actually it's a startup as of now. They will start a CLAT coaching soon. Means as of now we are promoting So Legal, and we are gathering students for our coaching school students for CLAT undergraduation preparation. So, and that's where I teach general knowledge, criminal law, and constitutional law. I'll be teaching like once we commence the classes, I'll be allotted these subjects. Yeah.
So also tell us about your law firm, LNS Associates. How does it serve as a legal education startup?
See, it's not a legal education startup. It's a full-grown it's my small law firm. It's my it's my journey. I established with this law firm with the help of my father in
Okay.
October 2020. That I thought that at least my firm should get registered and the office shared. Office gave in my firm's office gave in is like first. This is my chamber at home, and the other office, the official office, is shared, and my cabin of my chamber is shared with my father's office. Okay, I have allotted a separate cabin for my firm. So it's at a very initial stage. As of now, I deal with the criminal matter, property matter, and divorce matter. Okay, and apart from that, I'm not running a coaching. It's just that on weekends I conduct a small certificate course, and that's where I teach criminal law to the law student because I'm practicing criminal law. So I teach criminal law to the law students regarding the practical aspects. Okay, so that is how I manage all these things, that I study, I teach, and I practice. So it all are interconnected to each other.
So how do you deal with low phases of your professional life? Like you said that you are also preparing for the judicial services. So how do
Phase,
you
I'll
deal
tell
with?
you what slow phase is all about. I'm a first generation advocate from not from NLU, and first generation advocate. So yes, I have ample experience of facing low phase in my life. Okay, and there have been many incidents like I had also failed in my law school because of my indiscipline. I lost a valuable year, and after that, I realized my lesson about academics. After that, till now I've presented 25 research papers. I've spoken. This is my 30th webinar. I have my 7 research paper published. My 2 books are under process of publication. So that's how I decide. And that while dealing with low pace, there are only 2 words: determination. That बुरा वक्त है, बीत जाएगा. ओके, बुरा वक्त है, आई वुड से बुरा वक्त है, गुजर जाएगा. अच्छा वक्त भी आएगा, वो भी बीत जाएगा. सो इट्स पार्ट ऑफ लाइफ. एंड एज ऑफ नाउ आई वुड से कि अभी अच्छा वक्त चल रहा है, ये भी बीत जाएगा, बुरा वक्त भी आएगा. आई एम रेडी फॉर इट. आई एम रेडी. Yes, there will be a time, a bad phase will again come in my life. I have to deal with the same thing: determination and my experience which I have learned from my failure. Simple. So that's how it goes. And take criticism, take criticism, learn from your criticism, ensure that you don't give another person to criticize you twice. एक बार criticize कर लिया, okay, we will improve. Next time you won't get a chance to criticize me on the same topic. Then he has to look for another thing for the criticism. So it goes like this.
So you have experience in criminal law. So what do you think are the gray areas of criminal litigation in India, and how will they affect law graduates in the future?
It does affect the law graduate because we have to first accept this thing that the growth in criminal law is a bit slow. You have to wait. Why? Because unless and until you don't bring relief for your client, first of all, finding client for a first generation advocate is tough. You have to network a lot. And once you start getting client, unless and until you provide him, you give him bail, you some relief with the bail or some other reliefs. Until then, there is very least less chances that your practice will go. So you have to wait for at least good 2 to 3 years. Okay, just to wait for your time, and you have to keep on drilling, and you have to keep working hard, and you have to keep providing reliefs for your client. And it's not that okay, you are sitting at your chamber, a client will come, sir, this case has happened, please give me relief. No, you have to keep searching for the cases. Now suppose if you, and it's not that it's hardly a time that you'll get a case from the start. Means a case is going on, someone is not satisfied with his advocate, he will approach you that, sir, I need some relief, sir, please, get me bail, or my vehicle has got compounded, so please get it released, or I have to file a appeal in the high court. this has happened, or I have to file a revision, or on this aspect I have changed my advocate, so please go and do the argument, or please handle the cross examination. So all these aspects, you always get a case in the middle. Okay, you'll never get the case from the start, that you'll go and file the case also, you'll send the notice, summon, everything. It's very, the chances are minimal, unless and until you are taking check bounce cases, which also I take, and I also teach check dishonor cases also to my students. And as of now, for the check dishonor cases, they have got a very favorable response. So that is how the thing is. And the gray area is that it's very difficult on the part of defense advocate to establish that mens rea or the knowledge or the motive were not there in the crime. It was absent in that crime. So it becomes difficult, and yes, but we have to deal with it. That's the challenge we have to face, and that for that reason we take the fees. Okay, so that's our profession, and that's how we have to justify it. So that is how I go. And the another main aspect I feel is that the fresh graduates, they are not given any practical training in the law school. And when we go and you know when we enroll ourselves in the bar council, we pay minimum 11,000 to 25,000. It varies from state to state. And what actually happens is that we have to understand one more thing, that when we pay such a huge fees, it becomes the duty of the bar council to give them a proper training for at least 6 months about the court procedure, how the case is filed, how the drafting part is done, how the important argument is done, so that when he enters the profession, he is trained. Then he is not at the mercy of the senior. That senior will teach him something, and what happens? That senior exploits such juniors. They don't pay him, or pay him what? Law graduate, what is the stipend? 5,000, 6,000, 8,000, 4,000, 10,000. This is the this is the, and sometimes not even that. Why? They keep them for free, that you are learning at that time. So they should not keep any juniors. If you keep a junior, I'm not talking about interns, keep a junior only when you can pay him. If you don't have, if you, it's not about, I'm talking about the capacity, but if you don't have the intention to pay him, don't keep the junior. Simple. So we have to, and that's where, this 2 3, in fact sometimes 4 years also, this period is quite tough. And the people who don't have any financial support or other source of income, just like I have from teaching and from the legal research also, it's very hard to survive. And that's where people either take up petty jobs, or they look for some shortcuts, opting for unfair mean in their practice, and that's where it actually ruins their career and their reputation also. So that's why that will be my request, that please wait a bit. If you wish to uh, pursue your career in criminal law, it's a very highly rewarding career. It's very well paid career, but initial year you have to wait. So please, cut down on, I would say, cut down on your expenses, cut down on your wish list. Create a wish list there. Yes, when have income of 5 lakhs rupees a month, I'll do this, I'll do this, I'll do this. Why? Because I couldn't do all these things in my initial 3 years. Make a wish list. We can say that what should be the delay, the gratification, delay it, delay your wishes, cut down on your present expenses. Okay, and learn to survive. Trust me, at the end, it will help you in the longer run. Okay, so that's my advice, and that's what I have learned from my experience of last 2 years, from working in Supreme Court to working in Gurugram District Court. Okay.
Yeah, so this is a very important observation. I have seen that people, participate in moods because they have heard that it is important, but they don't know how to start with, or they are not given proper guidance how to argue before the judges, and how to prepare their arguments to begin with. So I think that is a really important thing, and it should be implemented irrespective of the college being an NLU or a non-NLU.
Yeah. It's not about NLU. One more thing I'll tell you about the moot court parts. I was judging a moot court from a trial moot court competition, and there was a team from NLU Shimla there, and they were from fourth year. And what kind of shabby drafting they did! I mean, really, this is how you draft? I mean, you see, when you draft, you ensure you write the name of the case in the body and rest of the remaining citation AIR XYZ, Supreme Court, High Court, whatever, in the footnotes.
Yes.
Do you expect a judge, if to whom you have not provided the compendium, to see the microscope and see, okay, this is the name of the case, is this how you cite? So that's the issue, that's the biggest hindrance actually the online education has given, because as of now we were not ready for online education, and suddenly we were subjected to online education, so we didn't transformed ourselves, or we didn't went in the phase manner from the physical classroom to the online classroom. It just happened suddenly, and the problem is the mentality also, that we don't even want to learn. That's one of the biggest problem also. So yes, this is something I would say that's a big problem.
So you are also a panel member of the World Cyber Security Forum. So what have your major takeaways been from that experience?
It's one of the amazing organizations whom I'm attached as of now. There have been many organizations which say, sir, we are inviting you to become our panel member. Sir, please accept our invitation. So I was like, fine. So they ask for my photograph. They make a amazing, beautiful poster, and then I don't get a call. Nothing. They do nothing. I was like, then why you have made me a panel member? What's your purpose? So as of now, like there are few organizations who actively engage their panel members. Is one is the Lex Auxilium, second of Apratim Day, second is Just Corpus by Ayush Pandey. Okay, and the best one, in fact, because it's the World Cyber Security Forum, because it's an organization of Paki Garg. She's an MIT University pass out, and she's my batchmate actually. Not batchmate, like we both passed out in 2019, and World Cyber Security Forum has panel member in the field of cyber law throughout the world, not only just in India. So when they organized a moot court competition, they invited the technology lawyers from all over the world, in fact, and they drafted a amazing moot court problem which was based on data theft and data sharing, and it's dealt with cross boundary, in the international aspect, means it involved the legal aspect of more than one country, and that is how the mood problem was faced. And in fact, for analyzing their mood code problems, I had to in fact read their mood problems for 1 hour, and that to 3 4 times, and then that's where I realized that, okay, this is how we have to deal with this mood code problem. And obviously they keep on organizing a certificate courses, and obviously it's one of the best organization, along with Just for Us, Lex Auxilium. It's one of the best organization I've ever come through. So being a panel member of WCSF, World Cyber Security Forum, and that too because I've completed my LLM in Information Technology Law, Cyber Law with a distinction. So it actually gave me an edge in getting a seat in such an amazing platform by Paki. Yeah.
So right now you talked about the legal education that has shifted online, and some people are not able to cope up with it. So what piece of advice do you have for students who are finding it difficult to cope with this
See,
virtual system?
although I don't agree with any politician, but they said aapda mein avsar. So whatever the situation is, I would say, my dear students, learn to get the best out of that situation. So what is the situation now? You guys are stuck in your law school. You guys are growing in your classes, means from second year to third year to fourth year, you are growing in your age numerically, but the mental growth is being stopped, because unless and until you don't meet people, you don't go out, there is no interaction, so the maturity level does not increase. So a third year student whose college life ended abruptly on May 2020, sorry, March 2020, and it will, because as they say, the third wave, fourth wave, fifth wave, I don't know why it does not come for one in one go, and it get the things done, it coming in installments. Okay, this COVID-19. So obviously one more year is also, we can easily expect that for next one more year, things will remain in this manner itself. Okay, so obviously we have to think that yes, this is the situation now. What we can do in this situation? So yes, first of all, there are a lot of online internships are a scam. You don't learn anything in online internships. Online certificate courses are even bigger scams. Although I also conduct online certificate courses, but still, being a faculty member, being a mentor, I'm telling you, online certificate courses are even bigger scams. Why? Because it has become a money making institute. Okay, platform money making platform for various organizations. Even I launched the certificate course, but my idea was I will launch a certificate course which is the cheapest in the market, and I will give the best quality product. So Priya Chaudhary, right? So if you see my response from my student in my LinkedIn profile, you can see it. So my wish was that if I keep 1500 rupees certificate course or 2000 rupees certificate course, and because I don't have any name, I'll get 50 students. So why don't I launch a certificate course of 1 month for 150 rupees? Okay, and I get 500 registrations, and I got 500 registrations. Okay, so I earned the same amount of money. The student didn't felt anything in giving 150 bucks, and they got I promised 115 classes for 150 rupees. I gave them 17 classes. Okay, so I increased the duration. So in now, so the motive should be clear, and why it has happened, the mentality aspect. Because of the excessive privatization, the mentality has developed that if something is expensive, it is good. Even you won't believe, even in my class of 500 students, uh, there was the regular attendance which existed from 120 students to 300 students. There were 100 students, and I keep on updating that if you feel that if something is wrong in my teaching, feel free to criticize. I'm open for criticism. But still, even after that, there were at least 100 to 120 students who didn't even attend one single class. Why? What was the motive? We have paid the fees, we'll get the certificate. So even I have decided you have not attended the class. Okay. So person who have attended the class, they will get the certificate. They'll get the certificate from my firm first, and you will get after 1 month. Simple. I promised I'll give you a certificate, but I never promised that I'll give you certificate if you don't attend the classes on time. I'll give you after 1 month. Give me the reason that why even after paying fees to me, you didn't attend one class. Give me one reason. Then take the certificate and tell me where am I wrong. Why? It's a mentality. Certificate. And I keep telling my students also, if you are studying from me, study for the purpose, take the certificate. Certificate is useless. Don't even take a printout because you will waste a page. You'll waste a A4 sheet page. It's of no use. Is that when I teach you how to read the Bare Act, how to analyze the words of the Bare Act, the proviso part, explanation part, the exception part, all these things, these are important. The knowledge which you gain in the certificate course is important. So if you want to join a certificate course, join it. I'll keep launching the certificate course, and that my target is I always study the market, and it should be like my course should be the cheapest. I Parleji strategy, like though Parleji has been selling his biscuit for 5 rupees from decades. So how it earn from the from the maximum sales. So I don't want to earn 1,000 rupees from one student. I want 1 rupee from every Indian, so I'll end up earning 138 crores. Okay, if we go through this manner. So obviously, I see that what is the courses which are being launched, okay, which are being launched by the other institute, and my course should be the cheapest, and my service should be the best. So my if I am offering the least expensive course in the market, I should have the maximum registration. So the financial part is also covered. I'm not saying that I'm some Sant Mahatma. No, I want to earn money. I'll honestly accept this fact on the front of the camera. Yes, I want to earn money like any other person. Money is important. We have to also run our kitchen. Okay. But how I earn money, that's more important. Second, on the part of students, guys, please हाथ जोड़ रहा हूँ प्लीज इसका मीम बना लेना मैम हाथ जोड़ रहा हूँ द बिगेस्ट ट्रुथ told to a law student is read more books. Sorry, lie. It's the biggest lie told to a law student, read more books. Please don't read books. I stopped reading books with folded hands, I'm telling you. Read Bare Acts first. First, read the Bare Acts. See, if you can see MP Jan, okay, IPC commentaries. This is part 1, part 2. This is part 3, part 4. Indian Evidence Act commentaries, Judicial Service books, AD Core. This is BD Mahajan. This is contract. This is company law. This is electronic evidence, and all these books you can see. This is Butterfly. This is international law book. Okay, all these books are there, but this book I will show you. R.A. Nelson. Okay, this is commentary, 5,800 bucks. But still, why I'm saying that don't read this. Read only this. This is your whatever your Bible, Bhagavad Gita, Quran, everything. This is not this. No, please. Why? I'll tell you why people when the, in the Prachin Kal when we had the physical classroom, why people used to do read commentaries first. Boys का तो पता है मुझे. अपनी girlfriend को impress करने के लिए कि they'll keep textbooks in the library and then they'll try to in the Hadish. I think we should apply this. Trust me, एक खींच के देने का मन करता था वहीं पे. What are you doing? If I ask how the word likely is interpreted in section 299 culpable homicide and how it is interpreted in section 300, बताओ मतलब this word is word का interpretation, or in fact the word meaning of injury is interpreted differently in section 299 and 300. बताओ Priya, why don't you give it a try?
So actually, I don't have a
It's okay. It's okay. Bare Act problem. Learn to read this. The word death in section 320, previous hurt, and the word death in section 300, murder. It's also death means admi is over, but still it is interpreted differently. Bare Act. Why? Because see, all these people, these jurists, even they are human beings. Whenever they write anything, every person is biased. So no matter how much they try to remain unbiased, somewhere down the line on any interpretation of law, they will interpret a law according to their own biasness. So when you read a book, you don't read a law. Priya, this for you and for everyone. When you read a book, you don't read a law. What do? You read, suppose if you are reading MP Jain, then you are reading MP Jain's interpretation of Indian Constitution. If you want to read Indian Constitution, first read the unbiased Bare Acts, then read the books. Otherwise, you will end up thinking like MP Jain. Then you will not think like Didi Vasu. Okay, so first read Bare Act, then read both the authors. Then you will understand how Didi Vasu interprets, how MP Jain interprets. Okay. Second thing, utilize this period to develop reading habit and stop using Google, stop watching Suits, stop using Google, stop watching Suits, and instead download live law. This I have said in at least in my 10 webinars. And focus more on reading part. Okay, read more, spend at least 1 hour every day on live law. Okay, download it, take yearly subscription, and do a lot of self study. Utilize this time to clear all your concepts. Find such mentors. Even I am such kind of mentors, but I cannot like overtly advertise myself. Yes, I have also been teaching, but if you don't like my face, my name, or my way of thinking or my way of teaching, no issues. But find a good mentor. Utilize this 1 year period to clarify everything and to have a command over at least IPC, Constitution, Evidence, Arbitration, CRPC, and CPC. 6. These is subject 1 year is sufficient to grasp, to cover all and to clear all your fundamentals of all these 6 subjects. And trust me, then you'll do a biggest favor on yourself if you utilize this period. Okay, so this will be my advice on this online education part, that yes, online education and certificate courses, online internships, they won't help you out. They are nothing but, for me, there are scams. Okay, and instead of spending money and time on that, please spend time more on self-learning, self-assessment. Okay, so yeah.
Okay. So you mentioned about being a distinction holder in your masters. So how do
I
you
also
believe?
mentioned that I failed in my law school. See, the thing was, uh, uh, for Bharati Vidyapeeth All India entrance, my All India rank was 2. Then I went to Pune. I failed year back, and then I focused again on the studies. After Babri Masjid case, I joined KR Mangalam. I opted for, because at that time all the LLM colleges admission were over, and I had not appeared for the LLM exam. So there's no excuse for this. But when I took admission in LLM, for me LLM was LLM. I appeared and I was serious in my LLM research. And my paper, my thesis, my dissertation was also on impact of cybercrime in the society. Okay, so, and I ended up being a distinction holder. I got 83%, and that's where I keep telling that, because I'm a distinction holder now. Now I can say focus on your marks. Imagine I would have completed my LLM with 52%, and I would have preached you, no, marks are very important. Score 75%. Itna hypocritic लगता ना? Okay, so that is why. And if you ask me, are marks are more important or extracurricular important? See, both are important. If you just focus on your marks, it shows that you are very studious in nature, but your rational thinking and your analytical skills are poor. So that's a job of a clerk. But if you do well, if you have every year you publish 2 3 good research papers in a good reputed journal, and the unpaid one, then what will happen? It shows that you have your, and you do a lot of moot courts also, you present a research papers also, then it shows that you will be a good lawyer. But at the same time, if you do well in the research and the moot courts, okay, you do well in your research and the moot courts, and you don't do well in your marks, then what does it show? You are not consistent. You do well in parts. Okay, so again, it's a setback. So when you score good marks and you do well in your extracurricular activities, it shows you are a consistent student. Okay, you are a consistent student, and you are a very smart student also. You are a rational thinker. Your interpretation skills, your research skills, your arguing skills are good. So that is the overall development of your personality. So it's not that you can ignore one and you can choose one. No, both are important. Okay, so I guess this was it, and I've answered like all your questions. So if you have any other question or doubt, feel free to ask. But I'm really thankful to Desi Kaanoon that they have approached this for a short interview, and I'll be always grateful to you. Yeah.